As a rule, where I referred to 92 bis motions, I made a mistake because I was dealing with 92 ter, but in this respect the rules for 92 bis and 92 ter statements are exactly the same. The Chamber is reluctant to receive the evidence in the form of transcript of testimony in other cases. It may be clear to the parties that that material is often very voluminous and that it's better presented by other means. Now, as a rule, the Rule 92 ter motions should not encompass any associated exhibits. Any exhibits that the party would like to tender with a witness should be presented as part of the examination chief of that witness. And this might be a reason for a party to request more time for examination in chief for that particular witness. The Chamber considers that it would be beneficial that those exhibits to be tendered in court with the witness are indicated already in the Rule 92 ter motion. As was proposed by the defence, the Chamber defers any decision on limitations on the time to be granted for cross-examination of Rule 92 ter witnesses. With regard to 92 bis motions, the Chamber provides the following guidance. Each Rule 92 bis motion should deal with no more than 5 to 10 witnesses each. The motions should be filed at least 2 to 3 weeks apart. In order to give the other party sufficient time to respond, so we don't want to have 30 or 40 92 bis motions at one moment. The first Rule 92 bis motion of the prosecution should be filed as early as possible and no later than 1 week after the filing of the prosecution's witness list. As with Rule 92 ter motions, I said it already before, Rule 92 bis motions should be limited to one statement per witness, clearly summarizing the witness's evidence, and the witness statement should also take the normal form of an ICTY witness statement, and as far as the transcripts are concerned, I already indicated what the approach of the Chamber in that respect would be. Only in exceptional circumstances we would be inclined to receive the evidence through those transcripts. As a rule, 92 bis motions should not encompass any associated exhibits. However, the Chamber recognizes that a particular Rule 92 bis witness might be the only individual able to provide the necessary context and the meaning to a document. Or at least he might be the individual who is best placed to do so. Such documents might be tendered through Rule 92 bis witnesses motions, provided that the witness in his statement clearly addresses the document and discusses its content. The Chamber expects each party to carefully assess whether a document should be attached to a motion or whether it is better tendered in court with other witnesses. The Chamber further expects that the number of associated exhibits for any Rule 92 bis witness will not exceed 5 documents. Should a party wish to exceptionally exceed this number, it should include a justification for this in the Rule 92 bis motion. Finally, the Chamber will give some guidance with regard to bar table submissions. As the parties will have understood from the guidance with regard to the associated exhibits, the Chamber prefers to have documentary evidence standard in court with witnesses who can give it proper contextualization. For this reason, bar table motions by the parties will only be accepted exceptionally and for a very limited amount of documents. Any bar table submission should be filed at the late stage of the party's case, when it is clear to the tendering party that the relevant document were not and could not have been tendered through any witness. A bar table submission should consist of a table including a short description of each document as well as its relevance and probative value, unless that's obvious from the description itself already. And further, the table should contain indicators of the document's authenticity. It should also include an explanation of how the document fits into the tendering party's case. In case of bulky documents with particularly relevant portions, the table should include a reference to those portions. Once a party has prepared such a bar table, it should provide it. I think the most logical way to do that would be in electronic form to the opposing party, which can then fill in empty columns in which it more or less responds to the proposal to have these documents admitted into evidence. I'm thinking of authenticity challenged for this and this reason, or so a brief position of the party, and I invite the parties to agree on a template, on a format for the submission to the table to be used with bar table submissions. The Chamber may provide further guidance on matters related to the presentation and the tendering of evidence at future status conferences. So this is not necessarily in every respect the end of the story. Not everything has been carved in stone yet, although this is the basis on which the Chamber intends to work. There may be a few novelties compared to what has happened in other cases. If there are any questions or any comments at this moment, I'd like to hear from the parties. Mr. Kuhn.
Your Honor, if I can inquire with respect to 92 quater, is the Chamber's preference for a statement over testimony hold true for 92 quater? The prosecution knows that some of its witnesses who are deceased we will be making 92 quater applications for, and whether the Chamber has a preference for the statement or the cross-examined testimony of that witness should it exist.
I see your point that you say to make to say more or less a consolidated statement is impossible if a witness is unavailable. It of course also depends on from what moment the witness is unavailable. If a witness would pass away a week before his testimony, then of course you would introduce him as a 92 bis or a 92 ters, and we would expect to have that one statement. But if it's clear right from the beginning that the witness is unavailable, we'll provide you with further guidance once I've discussed the matter with my colleagues how to operate in such situations. we have considered the practice which was developed in the various chambers of this tribunal, and which is certainly not the same everywhere. We'll consider it and we'll give you guidance.
Thank you, Your Honor. And one more matter. With respect to the maximum number of 10 witnesses for any 92 bis or ter application, the prosecution had considered that it might be of assistance for the Chamber if the prosecution had organized these motions into the topic or component of its case. For example, that we would make our applications for all intercept operators in one, and in this way thinking that the Chamber could make the most informed decision about the composition and mode of evidence that it would wish to receive and would be of the greatest assistance. In some cases, I anticipate that that would be more than 10 witnesses. So I'm inquiring from the Chamber whether that is a hard and fast rule, or is there some flexibility in cases in which it may make sense to deviate from it.
If you convince the Chamber that it makes sense to have 11 statements instead of not more than 10, if they all cover the same subject, then it's my assessment, without having consulted my colleagues, that that might be a successful attempt to suggest that to the Chamber. As I said before, nothing is carved in stone, but at the same time, the basic points are the points on which the Chamber wants to proceed. And of course, when we are talking about intercepts, and it may be unnecessarily to draw your attention to the fact that, of course, the rule on adjudicated facts specifically now refers also to authenticity of documents, and still to be decided whether that would be the transcripts of intercepts or also the intercepts themselves. But if that has been extensively dealt with in another case, of course, the first thought would be perhaps not to see whether this can be resolved by taking judicial notice of the authenticity of documents, rather than to receive a full set of evidence on the same issue again.
Thank you, Your Honor.
Any question as far as you are concerned, Mr. Lukic?
We have nothing now, Your Honor. We'll let the prosecutor lead their case the way they think is the best according to your rulings. So we have no questions we should ask now.
Then I will move on. And my next item on the agenda is rather open, miscellaneous matters. I'll start with an event which happened during the last status conference, because at the last status conference the arrival of Mr. Mladić was substantially delayed. At the time I stated that the Chamber would look into these events of his transport and inquire as to what measures had been taken so that it would not occur again. The Chamber, through informal communications, has made inquiries with the registry and has been informed that the delay was the result of an internal miscommunication with the unit responsible for his transport, and that steps have been taken to ensure that no such miscommunication or delay would occur again. Next issue, Mr. Groom, at the 65 term meeting, the Chamber invited the prosecution to file any additional submissions on the trial process in your next pre-trial report. You earlier had indicated that you were interested in making such submissions, and at the meeting you requested to make the submissions in a separate report that could be filed publicly. This request is granted, And at the 65 term meeting, it was already stated that the defense may also make submissions by filing a separate report. And these reports should be filed publicly if possible. Mr. Lukic, for the next item, if at any moment you feel that we would have to go into private session, please tell me. Because what I'm touching upon is the health issue. Mr. Lukic, the issue of the chamber having access to Mr. Mladic's medical information was raised at the 65 term meeting and in subsequent informal communications. The chamber is aware that your client gave a general consent to the chamber having this information at the first status conference, and also that Mr. Mladić again, so I did say so already at the first status conference, but he again gave a general consent for the chamber to be informed of his medical history and current situation. He gave that consent yesterday. However, the chamber wishes to clarify that you, as legal representative of Mr. Mladić, representing him in court, that you must take additional steps beyond providing the chamber with this consent if you are seeking certain actions due to concerns you may have related to Mr. Mladic's health. So if there's any other thing you'd like to action you take, then you may need to take additional steps. As you are aware, normally health and medical matters fall under the purview of the registry, and the chamber will only be involved in medical issues if they impact on the proceedings before it. And the chamber expects you or the prosecution to raise any such issues in a formal motion if you would wish to do so. Because of the medical issues brought to the attention of the chamber during the last few days, the chamber is currently considering to order a medical report addressing the full medical picture of the accused. Has either party any questions related to what I just said, or has either party a wish to make additional comments on the subject of Mr. Mladic's health? In inviting you to make any such submissions, I repeat that if you prefer to make them in private session, we would, of course, move into a private session. Mr. Lukic.
We don't think it's necessary to go to the private session. I think you got the report, because I got a report from the prosecution. I haven't received one on the Mr. Mladic's health and why he's not with us today. So whichever way you think is the best, or to inform the public or to keep you only for your honors, we will leave it for you.
The reason why the chamber would not be inclined to discuss these matters is because the chamber is of the view that if Mr. Mladić gives his consent to inform the chamber about the medical record, that is both history, where we have received information, and the present situation, we received a report today, that the chamber should use that information primarily in order to form its opinion on the impact it may have on the trial proceedings, and not to share that with the public. Now, you are Mr. Mladic's counsel. To what extent you want to share with, I take it, the consent of your client, matters with the public, I leave that, of course, to you. As far as I'm concerned, there's no need to do it at this moment. And I also will avoid to enter into a debate with you on the interpretation of any medical reports. So if you want to inform the public, I would say, following the media, you may have done so to some extent already. If I will not in any way respond to what you're saying, that does not mean that I would agree necessarily with your interpretation of what the doctors have reported and what is in the medical history of your client. So therefore I do not know, it's not necessarily relevant for our proceedings at this moment. We'll also further discuss at a later stage whether what is considered until now as private, that is medical information about your client, shared with the chamber to enable the chamber to form an opinion on whether and what impact it may have on the proceedings. Whether at any later stage the chamber would feel a need to share with the public some, all of, nothing of this information when deciding on matters as scheduling, that's a matter we'll consider at a later stage. At this moment, on the basis of the information we've received until now, the chamber feels no need either to discuss it, leaves it to you. Of course, the only thing is that the chamber would emphasize very much is that you and I, not being doctors, not to start interpreting medical information in such a way that it either minimizes what the real situation is, or to exaggerate on the other side, because I think no one, the last being the public, would be served by either downsizing or upgrading information on matters which we both are not experts in, and then rather have at a later stage, if there's any need, to put further questions to doctors about how to interpret, to do that in a organized way, and in this courtroom, whether in private or in public session. That's my guidance at this moment.
Thank you, Your Honor. Then I have nothing to add at this moment.
Mr. Groom.
Just briefly, Your Honor, the prosecution would inquire whether the chamber has considered whether there would be a benefit to separating the treatment function from the reporting function to the chamber, and have two doctors, one whose sole responsibility is to provide the chamber with objective information, and the other whose sole responsibility is the health and welfare of Mr. Mladić.
Yes, there are good reasons to make a distinction between doctors treating a patient and doctors reporting to the chamber, as was done in other cases before this tribunal as well. When I said that the chamber is currently considering to order a medical report addressing the full medical picture of the accused, this is one of the issues we are considering. Any further questions? Any further comments? Then my last question is whether there is any matter, any party would like to raise in addition to matters raised by the chamber or already raised by the parties.
Not from the prosecution, Your Honor.
Mr. Lukic.
We have nothing, Your Honor.
Then the last thing we have to think about is about the next status conference. The next Rule 65 Ter meeting will be held on the 5th of December 2011, and the next status conference is scheduled for the 8th of December 2011. And I would further remind the parties that the next progress report on agreed facts is due on the 25th of November of this year, as is the prosecution's next pre-trial report. We therefore adjourn until the 8th of December 2011, courtroom and exact time to be communicated by the registry at a later stage. We stand adjourned.
All rise. We will be.